Hey, oh, folks! Welcome. Gee, hold on. Just got home from work. Saw that still no verdict. What's going on? And I saw on Fox 5. Oh, there is a hearing on a school shooting in Georgia that happened just as I left Georgia. Remember, when I drove north from Atlanta, I went to the Sasquatch Museum. It's in Blue Ridge in the Appalachians. And not far from there was this school shooting. So this will be really, really interesting because this is not the trial of the school shooter. This is a hearing regarding the father of the school shooter. And this is something another person, a friend of mine, has experience in because he covered another trial of parents of a school shooter. Hello, Dave.
Hello. Yes, charge the parents, charge them all.
Yeah, I mean, now this, I don't remember much of the accusations against the parents regarding any abuse towards the child up in the case you covered. But according to what I can read here is that there has been numerous contacts with Georgia's child safety.
There was no abuse in the Crumbly case. It was more of a neglect element. It was they led him to his whims and they didn't take the proper steps to get him treatment. They basically neglected him. They weren't saying he was abused, but he was essentially neglected. That was the angle that they went with. So this is a little bit different, I suppose. But again, I have a hard time with this.
Yeah.
With the fundamental idea of charging non-participants in a violent crime. Because that's essentially what we're doing. We're charging non-participants in a violent crime. And it's not like, I remember everyone kept referring to Charles Manson. All right. So, but Charles Manson orchestrated it and instructed it and commanded it. And that's not what the Crumblies did. So I don't feel like it's on the same. But I'm not terribly familiar with this case other than the fact that it's the father being charged.
Yeah. And in this case, let's see here. Oh,
ham sandwich.
Yeah. I have here from the wiki about the 2024 Appalachia High School shooting. In August 2021, the son allegedly searched the internet for ideas on how to kill his father.
So not only is this guy guilty of this, he's also a potential victim. So we're going to charge the victim now, folks. We're charging the attempted victim.
And then you have different occasions here on October 31st, 2022. The Colt, as the kid here name is, was hit by his mother and along with his sister forced out of the house. They were let in again at 11 p.m. A neighbor who witnessed called the Georgia Child Welfare Agency. So he's been moving back and forth between the father and the mother. And
so it'll be an interesting one.
Yeah.
This will be an interesting one. I mean, yeah, it'll be interesting. Wasn't it the father's gun?
Let's see here.
If I'm not mistaken. I might be wrong on that. I don't know much about this case.
No, I must say, I mean, I remember I read about it when it happened because I just left Georgia when it happened. And I've just been through the appellations. So I took notice of it, but I did not actually.
While you're looking, I will say that I put this tie on. I changed my ties just for Joan since she's in the chat.
Oh.
I had a blue tie on. Really.
Oh. Oh, yeah. Well, it says here, during questioning in May of 2023, a year before this, both Colt and his father denied any knowledge of an email that was sent that the FBI took notice of, and that during the visit, pictures from the Discord account of the two weapons that was on a Discord account, they weren't shown to Colin to authenticate if they were his or not. So we have 2023 and 2024 with a lot of signs of there's something seriously wrong here. And child welfare was involved, FBI was involved, and still this happened. And this will be really interesting to see how this is turning out. But I will just we'll remove that one. We don't need that one. And because this hearing is today.
Okay.
And it's the father who the hearing is about. And by the way, the kid has not gotten through trial yet. He's still in pre-trial. So they are charging the dad for accessory and second degree and 8 counts of child cruelty and 29 counts before the son is even convicted.
Hey, hang on, I gotta take this call right back.
Oh, yeah. So that is what's going on.
Never mind, they hung up.
Oh, okay.
I thought it was a court.
So let's just listen in, because I think we can get more information out of this hearing than on Wikipedia and or articles.
Probably.
All right, let's go.
Is this Fulton County?
Nope. It's Broward County, I believe. Let's see where it is. Barrow County. It is. It is northeast of Atlanta. It's going to be 60 kilometers. What is that in miles?
There's a lot of background noise in the courtroom.
Yeah. Oh, there he is.
Be seated. Morning, Judge.
The judge doesn't have a robe on?
No. It's a yellow tie.
He's got style, even though he's got no robe.
All right. So this morning we have motions. We need Mr. Gray. Yeah.
Well, me and the judge look an awful lot alike.
Well,
Film live in the cool cafeteria. That's what it sounds like.
Ms. Daniel, did I send you an email about serious pending charges in our division?
You did. I went
Okay.
out yesterday, but
From earlier.
I just couldn't remember if I thought to do it or actually did it, so,
you did it actually.
all right.
We are a bit about an hour behind, so I have it on the.
All right, Mr. Gray is
The
present.
person else does something, and then you're sitting
Good
in a
morning.
prison jumpsuit for months
Mm.
or a year now, right? Almost a year. Someone else does something violent, and you're sitting in a prison jumpsuit for almost a year now. Just think about that, folks.
Yeah, the mass shooting, the shooting was September 4th, 2024. So it's not even a year ago,
Okay. Almost a year.
almost a year. And
But he
I'm
didn't
not-
pull the trigger. He didn't orchestrate it.
No, I mean, you can charge him for a lot if they see there was neglect and there was abuse on the son and everything. But if they charge the son as an adult,
Everyone gets to that. It's not the matter that it's an adult.
Yeah, I know, I
Look
know, I
at
know.
Squeaky Fromm was an adult, right?
Mm.
That's not the
Yeah, but
benchmark.
I don't know the facts of the case, if he stole the gun or if he got the gun somewhere else,
Right.
and or if he took his dad's gun. The Carrot Cat's mom says he broke rules of being responsible for the firearm. Well,
Maybe
yeah,
not.
but Georgia is really relaxed when it comes to gun laws.
Well, in the Michigan law that's currently on the books that says if you have a minor child in the house, someone under 18, you have to keep your gun locked and the ammunition separate and all that stuff. That law didn't exist when Ethan Crumbly went and pew-pewed his school. Yeah, his parents still got charged.
Yeah.
And convicted.
Yeah. So I'm guessing we are going to say a lot of these cases. Because if they charge them with second degree, well, I mean, the statute of limitations really isn't there.
Yep.
So it means, but yeah. So we'll see where this will end up, because if these are the tryout cases, and then what? Is every single mom of inner city kids responsible for what her kids are doing? I mean, or the gang members' moms? I mean, there really is no end to it.
Morning, we have motions today. I understand we have demurs.
Yes, Sean.
What else are y'all presenting today?
Judge, we just have a special demur as well as a general demur for today.
Okay, no other motions?
Not today, Judge.
Okay,
I think we still have a deadline per your scheduling order when some of the other motions should be filed.
yes, sir.
I know discovery is still in and coming. We got some more this week, so we're just kind of putting together our motions as the discovery comes in.
All right.
And they didn't file a motion to revisit the change of venue to know if that was, your plan was on that today or?
We can certainly, Judge. It's not going to be that 3 or 4 minute arguments.
Sure. I'm happy to entertain that today.
Oh, there's
All right. Fence can,
been there's one 4 months ago, Georgia v. Colin Gray, and that was via Law and Crime, and 8 months ago, preliminary hearing number 1 for Colin Gray. So that was 8 months ago. So they really nicked him in just a couple of months after the event.
Mm-hmm.
But we can go through this, and then I can try to go back to the first hearing. Or should we go with the first hearing? Because I believe then they have to say what the actual.
Yeah, the arraignment would have to do. I mean, you could go back after the fact.
Yeah. Let's check this one out first, and then we can go back. And
Yeah, the
see
courtroom
what
is really loud. I will say that. We can't hear you talk when the courtroom's playing.
Oh,
go ahead with their
is this better?
demurs.
Yes, much.
Yep. Okay.
Jimmy, do we do the special first? Sure.
Why was it body short?
Sorry.
Well,
Just we're gonna just for the states.
something about
Information. I'm gonna do
the
the general
gun
one first, and then
being
Mr. Barry's
too-
gonna do the special.
Okay.
I don't know.
Maybe we'll find out.
It's probably easier. for the
Yeah, we
court,
will
but I'll
find
get
out
that to the court.
eventually.
Yeah, we'll do the general first, and then we'll hit the special. The state can respond as we go.
And I'll keep it.
Just need the indictment.
I'll try and keep it simple, Judge, or straightforward. I know we're all pretty familiar with the facts of this case and what a general demurrer is. You know, the court is well aware. We are demurring as to counts 1 through 29 as being void for vagueness as applied and for failing to allege that the defendant's actions were the proximate cause of the deaths that have been charged in this case, as well as a reasonably foreseeable consequence of the defendant's actions in this case as well. I'll talk mostly about the vagueness. I think the proximate cause issue also bleeds over to the special demurrer. And so I know my co-counsel is going to touch much more extensively on proximate cause. So rather than do the same argument twice, I'm going to defer and let him make that argument as to proximate cause, as well as the prong of reasonably foreseeable
Closed caption
consequences.
is not available.
So in terms of vagueness, Judge, we're moving the court to dismiss counts 1 through 29 of the indictment because it rests on irreparably vague statutes stemming from the 14th Amendment's due process clause. The void for vagueness doctrine ensures that the people's representatives make certain conduct a crime. And as only the legislature may do, they must provide enough detail so that people of ordinary intelligence.
The proximate cause is
Okay, so here's the proximate cause in a nutshell. So there's two causes in any case. There's the but-for cause and the proximate cause. But-for is but for this specific thing that you did, this wouldn't have happened. But for him conceiving a child, the shooting would have happened, right? That's the but-for. The proximate causation is the foreseeability. Is it reasonably foreseeable to a person of ordinary intelligence and a normal, everyday person, reasonable, prudent person? Is it reasonably foreseeable that these events that this guy did would lead to the school pew-pewing? So that's the proximate causation. It all has to do with foreseeability. Yep.
You don't need to guess at what it is the state commands or forbids.
I'm sorry, is there a claim that the various statutes are unconstitutional?
Well, we think they're unconstitutional for vagueness, Your Honor.
Okay.
Based on, so for example, in the cruelty
I
in
would
the
agree.
second, it references cruel and excessive physical or mental pain. That would be one of the clauses we believe is vague as applied in this case. As to the reckless conduct, the involuntary manslaughter, the involuntary is based on reckless conduct, and the murder in the second degree is based on the cruelty to second degree. So the vagueness flows from the cruelty to the second up into the murder to the second as well. Then we believe that by not clearly defining the conduct, by leaving the definition of this conduct to, for example, prosecutors or judges to define, or more likely a jury to define, it creates a situation where the statute itself is unconstitutional for that vagueness. In federal vagueness cases,
The weak argument.
courts construe the statutory language in context, determining whether the statute itself or prior construction provides sufficient notice to the defendant. Reviewing Georgia law, this appears to be a case of the way this case is charged in regards to the cruelty of the second, meaning our client is charged by either doing or not doing certain actions that led a third party to do the action which makes up the basis of the cruelty in the second. By interjecting that third party, not only does that create issues with proximate cause, as my co-counsel will further elaborate on, but it also leaves not only the actions or the actions that define the crime vague, but it doesn't put an ordinary citizen on notice of what the prohibited conduct would be. And in terms of looking at case law for the Court of Appeals or for other courts or your honor to determine definitions of prior actions that have led to this charge, the way it's charged in this case by that extra third party causing the action that makes up the cruelty in the second, there's very little case law for the court to look at. And there's very little case law for my client to be informed on what the prohibited action is. Wholly separate from any federal claims, defendant also demurs to vagueness on both separation of powers and privileges or immunities grounds. In Georgia, all crimes are defined by the legislature. The power to define crimes and prescribed punishment has long been held to be an exclusively legislative power. And in criminal law, the legislation can only exercise that power constitutionally if it defines the crime with clarity and precision. When the legislature adopts a statute that renders an essential element subject to the jury's unfettered discretion, such in this case with the definition of cruel and excessive physical or mental, then we lack the clarity necessary to put the defendant on notice as to what it is the prescribed conduct is. By leaving that definition to the jury, then in each case, the jury itself construes the law for itself. What that means is that there's no chance that a final construction of the law that would occur and the limits and duty imposed remain unsettled until after the fact. Here, by constituting or by making what constitutes cruel or excessive mental or physical pain depends solely on the jury's discretion, the cruelty to children in the second statute is abdicating the legislative power to the judicial branch. And instead of knowing with certainty and definiteness what conduct is prohibited, the defendant is left at the dark, subject ex post facto to the random determination of the jury. Judge, we feel the same argument applies also to reckless conduct because it's also a statute that depends upon the determination of a jury after the fact as to what conduct constitutes a gross deviation. So it's the same argument in terms of abdicating the power of what the prescribed conduct is and taking that away from the legislator and bestowing it upon the judicial branch to determine. For those reasons, Judge, and I will just make for the record, we also believe that there's an issue with proximate cause and that my client's actions as this indictment has been charged were not only the proximate cause of the death charge, but also a reasonably foreseeable consequence. But as I said, I'll let Mr. Berry address that more fully in his presentation.
I don't know. I don't agree with this argument. Is it reasonably foreseeable that people who were pew-pewed could suffer extreme emotional distress?
Yeah, but was it foreseeable for the father? Because the father is charged with this. Was it foreseeable for him?
Well, that's what. But I don't like the argument because he's
no. I mean,
on...
the argument on leaving it to the jury. Well, yeah, they are the finders of facts.
Yeah, I mean, I think his argument should have been tailored to the actions of the father.
Yeah.
Could not. It couldn't be foreseeable that the school pew-pewing would happen based on the actions of the father. That's the foreseeability issue that I have. He's arguing that it's not foreseeable that people that were shot would suffer extreme distress, emotional distress. I think that's the weaker argument.
Yeah, of the two, that's definitely the weaker argument. But that we have not seen the prior pre-trial hearings, and as Karate Cat mom, yeah, the FBI spoke with the son regarding a school shooting post that they attributed to him. So that was the 2023 thing when FBI came home to them investigating a Discord post.
Yeah. Someone asked if I was at home or work. I am at home today because one of my cell phones decided to die yesterday, and I ordered a new one, and it's supposed to be here. And so I'm sitting at home waiting for my new cell phone. I do
Aw.
have court in like 20 minutes. I got to jump off, but I wanted to
Yeah.
hear as much as I can of this.
Okay, then let's continue.
Your Honor.
Thank you. Ms. Brooks? I assume Ms. Brooks, but
I factual lie.
Thank you, ma'am.
Your Honor, I have our cases on a job drive for the defense of the court. And I have a quick clarifying question. The actual general demurrer motion that was filed by defense does not allege anything about unconstitutionality, and it alleges just, the general demurrer that a crime was not alleged. So are they abandoning that allegation?
Judge, we won't abandon it, but we'll just leave it as it's been addressed in the motion for the court's determination.
That means he doesn't think that motion.
Well, I'll address the general demurrer first, Your Honor, and then Ms. Daniels pointing up some cases on constitutionality.
you're going to do the general or the specific? You argued the specific.
I argued the general and Mr.
I'm sorry, I thought I heard you say you.
Specific.
I was a little confused. Okay,
No problem, Judge.
go ahead.
So essentially, Your Honor, pursuant to Kimbrough versus State, which is 300 Georgia 878, a Supreme Court of Georgia case from 2017, to prevail on a general demurrer, an accused must be able to admit each and every fact alleged in the indictment and still be innocent of any crime. An indictment is sufficient to withstand a general demurrer if the admission of the facts alleged would lead necessarily to the conclusion that the accused is guilty of a crime. So ultimately, if the defendant's actions can rise to the level of criminal negligence, then the indictment is good against the general demurrer. And I think Kane versus State is a very informative case on this, and that's 287 Georgia Appellate Courts 45, a 2007 case. The defendant there was charged with cruelty to children in the second degree based on allegations that with criminal negligence, she had caused the children cruel and excessive physical and mental pain and suffering, to wit, a drowning death, by failing to reasonably supervise and reasonably watch said children.
That's how does that apply here? Because that was a direct action that caused the death of the children. Here the accusation or the charge is he did not foresee that his kid's actions would lead to something. So shouldn't case law, be somewhat directly applicable?
Well, the thing is that there's not a lot of case law on this. Like, I scoured Michigan case law when the Crumleys were charged, and there was only one case that was somewhat on point, and that was only somewhat. They're essentially creating new law each time they bring these charges.
Yeah.
So they need to stretch it.
I don't think the lawmakers had this situation in mind when they created the laws, and I try to quickly look at any law that was made in the past year, and I really can't find one.
And if there is a statute, it would have to exist prior to the
event.
pew-pewing,
Yeah.
so that
So she's mentioning case law from 2017 that really, in my opinion, doesn't apply here.
Yeah, they're stretching it. They have to.
Yeah, they have to
new
stretch
areas.
it because this will probably go up to appeal, and then the appeal court will say, yeah, it's okay, and all of a sudden there's new case law that they can then use for the rest. So this is a tryout case, just as up in Michigan and the Crumleys.
So there, the defense counsel argued the allegations of the indictment were insufficient to charge the defendant with a crime because failure to supervise or reasonably watch one's children does not amount to criminal negligence. The Court of Appeals held that the indictment was sufficient and found that while the failure to reasonably supervise one's child may not in itself constitute negligence, such dereliction certainly may rise to the level depending on the circumstances. And that is what we have here. The indictment is not subject to general demurrer because the conduct can rise to the level of criminal negligence. And each of the counts are based on criminal negligence, so the argument for each count is generally the same, and that's pursuant to Johnson versus State, which is 341 Georgia Appellate Courts 425, a 2017 case that stands for the proposition that reckless conduct and cruelty to children in the second degree are crimes involving criminal negligence. So while allowing a child access to a firearm and ammunition may not in itself be negligent, such recklessness may be negligent depending on the specific facts presented at trial. And in fact, the wording of our indictment specifically requires that defendant's conduct be reckless by alleging that defendant consciously disregarded a substantial and unjustifiable risk that his act of allowing his son access to a firearm with sufficient warning that his son was capable of harming others. So ultimately, if the defendant has sufficient warning that his son was dangerous, then he should have taken his AR-15 style rifle away from him. And not doing so before his son shot and killed
This
multiple
is general
people
negligence standard, which has never,
is criminally
it's
negligent.
never been criminal.
But whether or not the state has sufficient evidence is not the question before the court today. That's pursuant to Putnam versus State 257 Georgia Appellate Courts 902, which states that whether or not an act is criminally negligent is ultimately a question for the jury. The indictment adequately alleges a crime, and it's up for the jury to decide whether or not the state can prove.
As you said, she's using the general in order to get a specific. That's a stretch. So the case law she is attempting to apply here is about general negligence, where the victim is directly connected.
Yeah,
This
that's
is
the
two,
thing.
this is two steps away. Then
Yeah.
it can't be generality. Then, in my opinion, it has to be he actively handed him the gun,
Right.
not that it was just in on a shelf.
Yeah. So if someone recklessly fires a gun, it's foreseeable that could cause injury, great bodily harm, emotional distress to a person on the other end, right? But when you have an intentional intervening act, she's talking about negligence. So when you talk about negligence, when you have an intentional wrongful act as an intervening cause between the defendant's negligence and the plaintiff's injuries, that intervening cause always severs the negligent actor's liability, always. And she's trying to apply civil standards so that same intentional bifurcation should apply.
Yeah, but that's exactly what they did in the Crumbly case, and the judge held it.
Yeah, and we're going to the Court of Appeals today. Well, not today, but the brief's been filed.
Okay.
That the defendant is guilty beyond a reasonable doubt. There aren't any cases, obviously, with this specific set of facts in Georgia, but the appellate courts have found sufficient evidence for criminal negligence in circumstances analogous to this case. Other cases where children were allowed access to dangerous instruments or hazards. So while these cases are not based on general demurrers, one of them is, but most are not, what these cases show is that if properly alleged, an indictment would be good or would have been good against a general demurrer.
This is a circular argument. It is because we put it in the charging document. So this is more or less a circular argument.
Yeah. Oh, it's always a circular argument. Yeah.
So you have Turnip Seed versus State, which is 186 Georgia Appellate Courts 278, a 1988 case. And that case affirmed the conviction for involuntary manslaughter in the commission of reckless conduct. Even though at the time of the pit bull attack on the child, there was no state law specifically forbidding the ownership of pit bull terriers or specifically outlawing any one of the defendant's isolated acts regarding the dogs. This did not preclude the jury from finding that the acts of keeping the dogs and the circumstances evidence and leaving them unguarded, all with the knowledge of past incidents, built up to reckless conduct on this.
Yeah, but the kid is not a dog. This
Right.
is a
The kid is not a dog, and presumably the dog is like attacked the kid, right?
Yeah,
You know,
the-
so we
there
don't
were
have
pri-
the
pri-
intentional
there were pri-
wrongful acts of a third person intervening, which we do in this case.
Yeah. So it's strange. I mean, when they are talking 1988, usually the older the case, the weaker the case law.
Yeah,
If you have to
and
go back that
interesting,
long.
in Michigan, if a case is older than 1990, the courts don't have to follow it. It's just persuasive.
Yeah.
So
Yeah, I don't know how that applies to Georgia.
Occasion. So there, essentially, the defendant did not properly secure his pit bulls. They got out of the house and they killed a child. And that was found to be reckless, and that was found to be the basis for involuntary manslaughter. That case also found that the indictment was not subject to a
pause it
general
real
demurrer.
quick. Pause it.
And
If,
Baker
if there was, in that 1988 case, someone who intentionally let the dogs out to sick them on the child, I guarantee the dog owner would not have been charged in 1988. Right? Because there's an intentional wrongful actor that intervened.
Mm.
And so we have the same situation here, but they want to just change the law.
Yeah. Young is Fannie Willis behind this? No, this is a different county. This
If it was Fanny, she would have charged. She would have charged. them
it
under-
would be it would have been a RICO case.
Yeah,
if-
they conspired.
They conspired by leaving their gun behind a
What
lock.
did she say? Rico is fabulous or wonderful or something. I don't know.
Yeah.
It's just nonsense. It's
versus
never
State,
Rico.
which is
people.
280 Georgia 822, a 2006 case. That case held that evidence was sufficient to support a conviction for misdemeanor reckless conduct when the defendant left his 9-month-old and 3-year-old sons unsupervised on upper floor of a 2-story home near an unprotected flight of downward stairs. Again, did not.
Yeah, but this is still a direct action against the injured party.
Exactly. And again, if there was somebody who intentionally pushed them down the stairs, that father would not have been charged.
No.
Right?
If you leave the kids unsupervised upstairs and there's a older brother who, hey, let's push. Yeah, then it's the older brother's actions.
Depending on his age.
Yeah, depending on his age.
Yeah.
Did not secure his children away from a dangerous hazard. Reyes versus State, 242 Georgia Appellate Courts 170, a 2000 case, held the evidence was sufficient to support a mother's conviction for reckless conduct and failing to supervise a 3-year-old who was apparently.
These are all cases with a direct action. And they are claiming the indirect action of the defendant here.
Well, so they're talking about proximate causation, right? And so, but for the father leaving the children unattended, they would not have fallen. That's the but for. But then you also have the proximate causation. Yeah. Is it reasonably foreseeable that 2-year-olds or 3-year-olds would fall down the stairs if they were unsupervised? It's reasonably foreseeable.
Yeah.
Is it reasonably foreseeable that those kids would then, make like birds and jump off the roof? No, because presumably they didn't have access to the roof, right? So you have to look at the foreseeability of it. Yeah. But you're still talking about a direct causal link. Once there's a independent, intentional, wrongful actor that intercedes between the negligent act and the injury caused, that's not foreseeable.
Yeah, because it's legal to have a shotgun, or in this case, an AR style weapon on the shelf in Georgia. It's not foreseeable. Is it foreseeable that this kid, who was 14 at the time, would steal it and go shoot up a school?
attacked by an animal when evidence showed that the mother allowed her daughter to wander unsupervised, and the daughter was missing for more than 1 hour before the mom began looking for her. So again, not supervising her child, not preventing her access to the outside, and that resulted in reckless conduct. Johnson versus State, 341 Georgia Appellate Courts 425, a 2017 case, found evidence was sufficient to uphold involuntary manslaughter, reckless conduct, and cruelty to children in the second-degree convictions, where defendant left her 4, 3, and 2-year-old children completely unattended for an extended period of time in a room where they were sleeping on a mattress that was placed.
It's more or less the same case, just different variations of it that she is, and it's all the same thing. It's not applicable here, in my opinion. This is interesting because I believe it was in Judge Boyd's court in Texas. There was a guy who pled guilty because 3 years prior, his 5 or 6-year-old kid was on a swing and fell off the swing and broke a bone. And he got 12 months probation because at the time he walked in to get something, and when he got out again, kid had fallen off the swing.
Directly on the floor next to a space heater. Essentially, the court found that the mother knew that space heaters can catch fire, that they barricaded the children in the house so they could not leave, and when the space heater did catch fire and
completely different. The children on mattresses on the floor, a heater when too close to fabric can make the fabric take, but then the act here is they barricaded the kids in. Of course, that is enough for being upheld. It's really, really far-fetched, in my opinion.
killed 2 of the children. That was found to be reckless and also involuntary manslaughter. So again, they put the children next to a dangerous hazard and did nothing to prevent them from being injured. Johnson versus State, 292 Georgia 856, a 2013 case, held that a jury could reasonably have concluded, based on the evidence, that the defendant acted with willful wanton or reckless disregard for her son's safety, both in failing to prevent her son from accessing her methadone medication and in failing to seek medical treatment once it became clear he.
It's the same type of case. It's a direct action which led. Now, if Colt Gray, the kid who went to the school, now if he had taken that gun in the house and fired out the window, maybe even then, no.
I mean, was the dad home and watching it and encouraging it? I mean, there's a lot of things here.
Yeah,
but to my knowledge, the dad wasn't involved in any of this.
No, he did not hand over the gun.
How old was the kid again? I forget.
14 at the time.
Yeah, I don't know. It's still an intentional wrongful act of someone who's making an intentional choice, knows the difference between right and wrong. Like, there's a reason why these cases she cites are generally small, young children, because they're not of the age where they understand consequences for their actions, right from wrong. You presume that a 14-year-old does. And in this case, the state absolutely presumes that because they're charging them as an adult. All right. So if you take the idea that this individual who's acting intentionally understands right from wrong, it shouldn't make a difference whether or not this is a 14-year-old in that circumstance or that it's actually the father. Why isn't the mother charged? What if they took the gun from the mother, but dad had more control over the child because he was with the child more?
I think the mother and father didn't live together.
But I know, but let's assume dad had more of the parenting time, but the gun came from mom's. It's just, you're second guessing parenting after the fact.
Because
without
the mother in this
clear
case,
guidance.
Yeah, the mother in this case, as I read from the wiki, was a person who locked the kids out in the middle of November and didn't let them back in until 11 p.m.
That was the mother.
Yeah. So,
I don't like these cases at all.
no.
I got to jump off though. I've got to log into court.
Yeah, okay.
But while I'm waiting for Zoom, I'll be in chat.
Okay.
All right. See you guys.
See ya. Thanks for joining.
Was still.
Yeah, I don't know where
So
the gun
essentially,
was.
Your Honor,
I don't know
those
enough
cases show that
about this case. I'm learning
an
of it as
indictment
you
for
learn
reckless
of it.
conduct is sufficient against a general demurrer if it alleges a crime. The crime here being not preventing his child access to a gun when he had knowledge, when he had warning that his child was dangerous. And if the jury finds that he should have taken the gun away from him, then it is criminally negligent and he can be found guilty of these charges. And the state is just requesting that you let the jury decide that and not grant a general demurrer.
What's your best case on it, Mr. Hobbs? I know it's, nothing may be directly on point, but
Sure, Judge. As to, and Mr. Berry will give the court this information more in his argument, but as to the proximate cause, reasonable consequence, there's Bell v. State, which is 317 Georgia 519. That is a Georgia Supreme Court case. And I never know how to say this one, but there's Melancon, Melancon v. State. And do you have the site for that, Mr. Berry?
I do, Judge. I have copies of those.
Okay.
That I can put in.
yes, sir. Mr. Hobbs, did you want?
Yeah, I agree with Dave. Like it that the judge asked for the best case here. And I just found out here that a judge has agreed to move the trial for Colt Gray, but he has still not determined whether to export the trial or import a jury.
To make any final argument on the specific demurrer?
Judge, I think both arguments are fairly clear, and I think the court has a pretty good grasp of what we're dealing with this. Obviously, this case is a little bit different than the cases that were cited just based on there being a third party in the form of Mr. Colt Gray who actually committed the action which is intended, but I know the court's aware of that and will rule appropriately. Thank you, Judge.
All right, thank you. Mr. Berry, you want to do the general?
Thank you, Judge. Good morning.
Good morning. The specific, yeah, you want to do the specific.
Yana, the thing that we know about the indictment in this case is that he's not charged as a party to a crime nor as a co-conspirator. So it's kind of a hybrid indictment. In all 29 counts, it's interesting that the language is exactly the same in all 29 counts as to what allegedly occurred. I've given the court the case of Melancon. I think that is the leading case right now. There are a couple of cases that are going up, have been asserted up to the Supreme Court, but I think this is the leading case right now. It was decided in September of last year. And basically what it says, Judge, is that for each kind of murder set out in our statute, the state must prove that the accused caused the death of another human being. In looking at all of the previous cases that led up to Melancon, cause is broken down into two parts: a cause in fact and legal cause, which they have outlined in Melancon as proximate cause. In addition to cause in fact, the decisions describe a separate requirement that they call proximate cause. That's in Bell versus the state at 317 Georgia, 523. Eubanks versus the state, 317 Georgia, 563 and 565. And Jackson versus the state at 287 Georgia, 648 and 649. The overall elements of causation required, the murder causes is proximate cause, and that elements include cause in fact and legal cause. Legal cause requires foreseeability or likelihood of death happening in the way that it did or alleged in the indictment, which gives the defendant the conduct which they allege. When you look at the indictment based on Melicon, there's some striking things that you see. In the beginning of the wording, they say consciously disregarding a substantial and unjustifiable risk. This is the language that's used in reckless conduct, but they use it in each one of the charges. All 29 charges uses this same wording. The problem is you are using wording from reckless conduct in a murder charge, murder in the second degree, which is very vague. Which one are they talking about? Are they going to argue reckless conduct, or are they going to argue murder in the second? That language should not be in the indictment. Secondly, in looking at the indictment, they indicate that access to firearms is an issue. There's no requirement under Georgia law that people have their guns locked away. I think it's come before the legislature a couple of times. That has not been, no law has been passed in that regard. Even if you lock your guns away, what is access? Somebody can break into a gun case, get the guns out. So what do you mean by access? Is it just that everybody's going to have to get rid of their guns if they have kids under a certain age? We don't know. It's not specific in the indictment.
Now, let me ask, so just trying to think of an analogy there. There's no law that says you can't leave your prescribed narcotics on the coffee table. But you could certainly be charged if you left open.
What? I'm quite sure there is a law against leaving illegal drugs out in your home in Georgia.
Prescribed narcotics on a coffee table and a child
Oh, prescribed
came and
narcotics. Okay.
overdosed. I mean, would you disagree with that, or?
Well, you can take that analogy a lot of different directions. If I have an automobile, I have a 16-year-old, and I know my 16-year-old's gotten a couple of speeding tickets, but I leave the keys in the kitchen. And my 16-year-old gets the keys, drives down the road, runs into somebody and kills them. The access to the keys, is that the proximate cause of the murder? It's very vague at best. And that's why we're saying the indictment is vague in and of itself on a number of levels. That just being one of them.
I like it that he used the car analogy. I remember we made the analogy, would they have charged the Crumblies if their kid used a knife? Or is it just because it was a gun? Because murder is still murder, weapon is still weapon, but would they have charged the parents if he had used a knife? And here, this analogy is even better. They used 16-year-old, takes the keys to the car that is on the kitchen table, drives off and kills somebody. Are they responsible for leaving the keys out?
And I realize we have a uniqueness here with the third-party actor.
Correct. This is one of the most bothersome parts of the indictment to me, is it says, after receiving sufficient warning, we don't have any clue what that sufficient warning is. I don't know. I've looked at all of the discovery. I don't know what that sufficient warning is. It doesn't outline it in the indictment. So how do I know what a sufficient warning is? Is it your son's having some problems? Is that a sufficient warning? I don't know, because the indictment does not say. So how can we say that a warning is the proximate cause? Because we don't know what that warning is. It's interesting, too, that in the indictment, it alleges that this occurred on or about September the 4th, on or about September 4th. We don't know what sufficient warning he received on or about September 4th, because they put it kind of in a capsule. It's got to be close to September the 4th. We don't know what that warning was close to September the 4th. And was it sufficient? What does sufficient mean? How do we know? Because they haven't outlined it in the indictment. The next part of the indictment, which is confusing, is that Colt would, after getting this sufficient warning, that he would cause bodily injury to somebody. Now, where in the indictment does it tell us that he knew he would? Not that he may, but knew. It's not in the indictment. We don't know how in the world he would have known unless Colt told him. We've got Colt's statement, unless he's made some other statement that we don't have. He's not made that claim. So how would he know that? We don't know. The indictment doesn't tell us. The indictment basically, I think, Judge, shows some conclusions that the state has. But what we have to have in an indictment is primary facts. We have to have some facts to go on. So in this indictment, the reason we've demurred to this indictment especially is that the state's failure to properly allege the probable cause issue. There's nowhere in the indictment that it uses the word probable cause. And two, the state's failure to allege that the death was reasonably foreseeable consequence of the defendant's action. And we don't know whether it's the defendant's action or inaction. They really haven't told us whether it was an action or an inaction that the defendant did in this indictment. Since they were not alleged in the indictment, there's no way to determine whether the grand jury found sufficient probable cause to issue a true bill. Additionally, the indictment lacks specificity as to material elements of an indictment. For those reasons, Judge, and I think the indictment just is very vague. It does not put us on notice of exactly what we have to defend. It does not allege probable cause or foreseeability of this knowledge. So it, in our opinion, it's too vague and should be either the state can redo it or this should be thrown out. Thank you.
Thank you. Ms. Brooks?
Yes, Your Honor.
Okay.
Well, to begin with, as I stated earlier, reckless conduct in criminal is regarding criminal negligence, and so is cruelty to children in the second degree. The only difference is that cruelty to children involves a child, reckless conduct would involve an adult. So the language can be the same because it's essentially the same charge with the only difference being the age of the victim. Involuntary manslaughter is based on the death of an adult. Cruelty to children in the second, or murder in the second, is based on the death of a child. And I think it's important, Your Honor, when we are talking about special demurrers, that we actually cite what the law and what the standard is. And under State versus Lehman, 279 Georgia 340, a 2005 case, while it says an indictment must be perfect in form, that does not mean that the state has to allege every fact and every piece of evidence that we are relying on in proving our case. What
But you're 8 months in now from where he, at least I can see here, he had his first preliminary hearing 8 months ago, I believe, which is 3 months after. So by now it should really go into specifics. What are you actually alleging? And what was the foreseeable act? And why was it foreseeable? That should be in the indictment. Apparently, it isn't. So even though it must be perfect in form, it doesn't say much about the content. It still has to move within the boundaries of the law, the right for a defendant to know what he is accused of. And being general neglect, specific neglect, well, you have, if you claim specific, you have to be specific.
the defense appears to want us to do is to go through each and every piece of evidence that we have and each and every fact that we have, but that is not the purpose of an indictment. The true test of the sufficiency of an indictment is not whether it could have been more definite or certain. It is whether the indictment, 1, contains the elements of the offense intended to be charged, and 2, alleges the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And that's under Hinkson versus State, 310 Georgia 388, the 2020 case. In considering whether the indictment is insufficient, it is informative to remember that the purpose of an indictment is to allow the defendant to prepare a defense. It is not for us to tell them everything that we are going to present at trial.
This is a bad. This is a fallacy. What she's using here, she's using the all or nothing fallacy, the black and white fallacy. She's saying we don't have to tell them everything. Nobody's arguing. You have to go that much into detail, but the defendant still have a right to know what he is defending himself against. This is Derek says, they're saying their indictment doesn't have to be right, so they can add what they want to it as they go along. They don't want to add to it at all. They want to present their evidence at trial more or less. They're trying not to show their hand, because the moment they show their hand, in this case, be more specific, not be telling 100% of everything, as the fallacy here implies, but he needs to know what to defend himself against. And if she makes specific claims in the indictment that this he did wrong and this is why he should have foreseen it, then the defense can be specific in their motions to quash or motions to dismiss. But now they can't, because the prosecution is too vague. So I really don't like her argument here. It's not an argument, it's a fallacy.
In discovery, they know what we are presenting at trial. We are not required to outline every piece of evidence in our indictment. As far as each count in the indictment, the state did allege each and every essential element, which is prong one of the requirements to withstand a special demurrer. So for cruelty to children, those elements are 1, cause cruel or excessive, 2, physical or mental pain, 3, to a child under 18, 4, through criminal negligence. And here we charge each of those elements. We charge the type of pain, the name of the child, and what act constituted criminal negligence, which is, quote, consciously disregarding a substantial and unjustifiable risk that defendant's act of allowing his minor son access to a firearm and ammunition after receiving sufficient warning that defendant's son would harm and endanger the bodily safety of another.
Yeah, but what was that sufficient warning? Yeah, they did have a home visit from FBI the year prior. Now, does that count? Well,
That is his act of criminal negligence. And essentially, it's the same thing for reckless conduct. We indicted each and every essential element that is outlined in OCGA 16560 and charged the defendant with the harm that he caused, the victim's name, and the specific act of criminal negligence. Now, for murder in the second degree and reckless conduct, it's essentially the same elements, but you add proximate cause. And to go along with the defense counsel's analogy, whether or not you know that the 16-year-old driving the car, the dad giving him access to that car, was the proximate cause of death is up for a jury to decide. It's whether or not the jury finds that it was reasonable.
no, it isn't. That is a matter of law, and that is up to the judge. Is it sufficient to leave your keys at the table, your car keys at the table? Is that sufficient to a probable cause? Is that sufficient to bring an indictment? That is a matter of law. That is up to the judge. I believe she's really wrong here. Derek, I don't know yet if it was the father's gun or if it was the kid's own gun. It sounds like it was the father's gun.
Foreseeable that the child would kill somebody. And that is the same case here. Something is a proximate cause of someone's death.
How is it foreseeable that if I leave my car keys on the table, my 16-year-old grabs it, takes the car, takes off, and then commits vehicular homicide? How is that foreseeable?
The person could reasonably foresee that someone would die as a result of the actions.
If you're using that analogy, then find a case law where a 16-year-old drove down, killed somebody, and there was a charge against the father or the mother.
Pursuant to Eubanks v. State, 317 Georgia, 563, a 2023 case, proximate cause requires that the death actually happened in a way that was a reasonably foreseeable result of the criminal conduct. But what constitutes proximate cause is undeniably a jury question and is always to be determined on the facts of the case. And that's Butler v. State, 363.
She's again using a direct cause to explain an indirect cause. I don't like her argument at all.
Georgia Appellate Court 753, a 2022 case. And for indictment purposes, what that means is that the state has to allege an act that could, under any circumstances, result in the death of another. Under any circumstances, be the proximate cause of the death. That's Skraders versus State, 263 Georgia Appellate Court 754, a 2003 case, and Funk v. State, 296 Georgia 371, a 2015 case. And in this case, the state alleged that the defendant acted with criminal.
Oh, did you notice how she did not in these these cases? She didn't mention what the actual cause was that the jury or the court found. That's
criminal negligence by disregarding a substantial and unjustifiable risk, that is act of allowing his son access to a firearm, again, after receiving sufficient warning that his son would harm another. The plain language in the indictment requires that harming another by use of a firearm be within defendant's knowledge and therefore reasonably foreseeable. We put the wording in there of sufficient warning. The defendant had to know that his son was going to do something or was capable of doing something in order for him to be responsible for the actions of his son. And that in itself is reasonably foreseeable in the indictment.
That is a circular argument. It's a fallacy.
And going along to the next argument that the state should have been more specific with regard to whether or not we charge party to a crime, what access the defendant gave his son, and what warnings specifically he had. Well, again, an indictment does not have to contain every detail of the crime to withstand a special demurrer, and that's Kimbrough versus State, 300 Georgia, 878, a 2017 case. And again, sufficiency of the evidence is separate and distinct from sufficiency of the indictment, and that's State versus Hart, 183 Georgia Appellate Court, 737. According to Scruggs versus State, 309 Georgia Appellate Court 569, a 2011 case, the state does not need to spell out in the indictment the evidence on which it relies for a conviction. Simply put, the law does not require the state to further define essential elements of the crime. We have to put what the essential elements are. We have to apprise the defendant of the evidence he is to meet so that he can prepare a defense, and the state has done that. And I want to go through some examples. Again, we have a unique set of facts, but we have a lot of cases, a lot of charges from where additional facts are not required. So you have Hinkson versus State, 310 Georgia 388, and Arthur.
Do you think they are trying not to bring up the Discord stuff because then we'll have to explain the FBI stuff? Yeah, because the FBI, according to what I read, said there were no probable cause regarding everything around the Discord thing. So, yeah, that is kind of a big deal because if the FBI says in 2023 there's no probable cause, then what's the warning?
Versus State, 275 Georgia 790, which hold that for aggravated assault, an indictment need not say how the defendant used the weapon or even what that actual weapon was. So to say that we have to put the exact warning and the exact access would contradict the fact that you don't even have to put what the weapon was in an aggravated assault. State versus Tate, 262 Georgia Appellate Courts 311, the 2003 case, found that a terroristic threats indictment only alleging the crime of violence that was threatened as opposed to the actual wording of the threat was sufficient. So all they had to say was, did threaten a crime of violence, to wit murder, and that was fine. They didn't have to say exactly what he said. They didn't have to say the means of communication for the terroristic threats. And Snyder versus State, 238 Georgia Appellate Courts 55, a 1999 case, an indictment for cruelty to children and child molestation did not allege the specific immoral and indecent act that constituted child molestation and cruelty to children. And that was found sufficient. So they didn't even have to say how the defendant molested the child or caused the pain, and that was fine. In South versus State, 268 Georgia Appellate Courts 110, a 2004 case, that was an aggravated stalking indictment that was sufficient even though it didn't allege the exact ways in which the acts of aggravated stalking occurred. So in this case, the state has put the defendant on notice, the incident date, and he argues that we did not provide a detailed date or that the date isn't sufficient. Well, what the date is the date that the defendant giving his child access to a gun resulted in people dying and people being injured. That is the date. We didn't say the date of the warning. It was what knowledge he had at the time he allowed his child to have access. And that is the date. And that was
allowed the child to have access. But there is no law, we heard that, in Georgia that says you have to lock up your gun. Which means that the warning has to be specific. How do you get to the specific if you don't bring in what the actual supposed warning was? And if you do, then you have, okay, the Discord thing. Well, according to what I read, the FBI found no probable cause. And so what's the warning? Well, yeah, give us some facts. Just saying he had warning. What was the warning?
September 4th of 2024. They are on notice of the date. They are on notice of the specific victims' names. They're on notice of the act that the state is alleging was criminally negligent. Again, giving his son access to a firearm, not taking it away when he knew that his child could harm others. And we allege that the defendant's actions were the proximate cause of the deaths of Christian Angelo, Mason Spermelhorn, David Aspinwall, and Christina Yermy. Specifically with regard to party to a crime, the state doesn't have to allege that. That is long settled law. There's no requirement that we put in any sort of indictment that the defendant was a party to the crime of someone else's actions. So that is under Leaks versus State, 303 Georgia 104, a 2018 case. Indictment did not need to be charged with defendant's culpability in it to be proved in that manner.
I'm trying to read up on this at the same time. Derek asks, so this guy's son ends and injures others, but they are saying the father did the same. Well, he is charged with second degree, not first degree, but more or less, yes. Did he ask his father for the gun, then went out and shot up a school? I don't, of what I can interpret is that the son took the gun. And that the prosecution is trying to get to, he allowed his son to take the gun. I don't think you get there by just having it legally in your home in Georgia. Now, the dad might be an absolute asshole, but that's not a crime. So what we need to know, or the defense needs to know, what is the supposed warning that they claim? Because they have to defend themselves against the facts of the case, or the alleged facts of the case. And this is way too vague for me at least.
That is also Metz versus State, 284 Georgia 614, a 2008 case. The law is well settled in Georgia that the state is not required to specify in the indictment that it is charging the defendant as a party to the crime. Specifically with regard to the warning that the state alleged, indictment after, or charge after charge has the phrase knew or should have known in it. And the term sufficient warning is analogous to knew or should have known. Statutes like theft by receiving under OCGA 1687, which requires the defendant knew or should have known the property was stolen. Drive-by shooting under 1615 4.1 requires a defendant knew or should have known a building at which he fired a gun was occupied. or harming a public safety animal, OCGA 1611.
But all of that are direct acts. All of those are direct acts of the accused. There are no direct acts. You claim negligence by him leaving the rifle or the AR type gun out. This is
7 that requires that the defendant knew or should have known the animal harmed was a public safety animal. There's no requirement in the law that demands that the state allege what knowledge the defendant had in each of these cases. And it's the same in this case. There is nothing that says the state has to prove these specific warnings or the specific knowledge that the defendant had when he let his son have a firearm. Requiring the state to outline each and every warning that the defendant had would not only make this indictment entirely unwieldy and just pages upon pages long, but would also require the state to prove elements that is not required to under the law, and it would give us a heightened burden of proof that we are not required to have. Ultimately, it is for the jury to decide whether the evidence presented is sufficient to prove that defendant's knowledge and actions rose to a level of criminal negligence. And the state respectfully requests that the court allow the jury to do that and deny the special demurrer.
Thank you, Mr. Berry.
Thank you, Judge.
I like these
One
guys'
thing the
argument
state
better
didn't
than
talk
the
about
other
is this new case, Melancon. It requires that you allege proximate cause. They don't do that. They don't say that because he got this notice, that was the proximate cause of the death. Because of the access, that was the proximate cause of the death, or foreseeability. Both of those are outlined in the Melancon case, and I think that certainly it's very important. And when we don't expect, and we know that indictments are not perfect. However, you are to put in an indictment what you allege that you're going to prove. You have to put us on notice what that is. And if you read the indictment, and they say some of the cases say it's just known that it's knew or should have known, that's not what's in the indictment. That's very specific. He knew because he was given specific warnings on or about, and they said, well, we don't have to put exact date that he got the warning, but that's not what the indictment reads. The indictment reads that all of this was on or about the 4th of September. So we have to assume that that notice was given on the 4th of September because that's what's in the indictment. No knew or should have known. And I think when you read the Melancon case, which is a case from last September, it's the most recent case. There are 2 cases that have gone up to the Supreme Court with similar situations. They have not been decided yet, but this is the leading case right now on what proximate cause, what you have to show in proximate cause. And none of the things that they put in that case are alleged in the indictment. And we still believe, Judge, that they should give us some information as to exactly how this specific warning was given, by whom to him, when he got it, how he got it, what that warning was. I mean, how do we argue proximate cause if we don't know what the warning was? It's not in the indictment. So we're not asking for a perfect indictment. We're just asking for one that we know what the heck we got to argue. And that's what we don't have. Thank you, Judge.
Thank you.
And Your Honor, I know he gets a lot of words. He gets correct a brief misstatement. The Melancon case is not a case about a special demurrer. It's a case about sufficiency of the evidence. It doesn't outline what is required to be in an indictment. It outlines what is required for the state to prove at trial for proximate cause. Again, it's sufficiency of the evidence, and that is not what today is about.
To make sure you get last word, go ahead.
Thanks, Judge. And that's correct. However, it outlines what it is. And obviously, if you don't have that in the indictment, you got to go back and say, okay, that should have been put in the indictment. So even though what they say is true in one regard, it's still the law that you need to put it in there now, because that's what Malicon said.
So I know the state just this morning in open court filed their brief. What are y'all's opinions on submitting proposed orders?
Your Honor, we can do that. We can adjust.
I assume you can turn your brief into one. I don't know about the defense.
Like it's that.
Yeah, this is throwing
Yeah.
half-cooked spaghetti at the wall and hoping something sticks.
Well, we can certainly submit a proposed order, Judge. If you would like us to submit a brief, we would simply ask for about a day. We can have it approved to your honor pretty quickly if you'd like one.
The proposed order citing the law and such would be sufficient if you're okay with that.
We are. Thank you.
I missed how long you wanted for that.
How about a week, Judge?
Sure.
Thank you.
All right. So I've just been handed the scheduling order, so I could look at that. So number one says all discovery in the possession of the state be served on the defense on or before June 16th, which is yesterday.
Yes.
Where do we stand with that?
We served everything that was in our possession. I think there are a few outstanding things that we requested that we have not gotten. I don't think it's a significant amount, but the majority of all the items that we are going to get have been retrieved by the state, have been served on the defendant. Obviously, we'll be serving jail calls on an ongoing basis, and if there are any additional witnesses we come upon in interviews, we would serve those as well.
What sort of evidence you say you don't have yet? I want to make sure we don't run into a situation where they're handed 1,000 pages of.
We have a list.
So yesterday was last day of discovery, and they haven't handed over everything yet. Did they ask for more time before today? If not, tough luck.
So the majority of the stuff that we're still waiting on, we're waiting on a few medical records from some of the victims, which won't be much to see. We are waiting on some certified copies of search warrants, there were some additional school records of the defendant's son that we had not received, where he had been at for a short period of time. We're waiting on those. And I think the only thing that appears to be a little bit more lengthy would be call detail records for the defendant we already have provided what we have. I think we've asked for some additional call detail records, and those have not come in yet.
Do you have any kind of estimated timeline of when you're going to?
We have,
I would think school records.
school records should be, I know we've received emails back from the school saying they are working on it. So we assume that'll be hopefully this week. Medical records, usually those are pretty quick. We've been working on those for a while at this point. And then as far as the CDR records, we did do a search warrant. I think it was maybe a month ago. It's been 3 weeks ago. So that should be soon as well.
Okay. I know y'all will be, but just continue to be diligent in accessing that so that the defense has it in a timely manner.
Yes, Your Honor.
Why have these cutoffs if the state are allowed to ignore it? Why? Why have these cutoff dates when you allow the state to ignore it? If they must have known this on the 15th. Throw in a motion, we need more time. Instead, the day after, yeah, we need more time. Sorry. This is so lazy. Even if this is a smaller county, they have the manpower and budget for all of this, and they still don't have it.
As y'all don't have all the discovery, but what other anticipated motions do you believe we're going to hear?
Yeah, I mean, Mr. King, has it ever been enforced?
Judge, I think we've got some motions to suppress that
No.
we're going to be filing.
Okay.
And there are some that we'll need to speak with the court without the district attorney present, dealing with psychiatric situations.
So I just want to make sure, obviously, we're scheduled to commence the trial September 8th. I want to make sure that we have time to get in court, argue the motions, time to rule on them. If things get tight in the summer, but there's a judges conference 1 week towards the end of July, vacations, but okay. So we do need to confer and maybe just go ahead and get a do we have a backstop already for a day to argue those motions? Have y'all talked about that with Mandy?
We have, Judge.
Okay.
She gave us some additional dates other than this one, so if those are still available, we can look and come up with a date.
Do you anticipate any of the motions taking more than a day or half day to present and argue?
I don't think so.
Okay.
And Your Honor, it won't take this long to prepare the motions, just more of a matter of witness availability. So the sooner we know, obviously, what witnesses would be required, then the sooner we can make sure that they're available for whatever day.
All right.
Maybe after our deadline of the 15th, we'll try to come over and sit down with the state,
Okay.
see if we can go through some of those ahead of time.
And then, and I'm certainly okay with y'all filing them before the 15th. All right, and y'all filed a motion to reconsider the change of venue, is that right?
We did, Judge.
Y'all want to address that?
Yes, Your Honor, won't take a minute. Judge, we're concerned over.
Yeah, back in April, they got change of venue approved, but not, the judge hadn't decided if he moves the entire trial out or if he imports a jury. And apparently now the defense have a change of heart.
Where the court has chosen to move this case, Hall County. Hall County is contiguous to this county.
At a tip, but go ahead.
It's still contiguous, at least in our perspective it is.
Yes, sir.
The thing that we're concerned about also is some of the witnesses in this case are from Hall County. Hall County was where they raised about $50,000 through their T-shirt. They were done in Hall County.
Tell me more about that. I don't remember hearing Hall County with a T-shirt fundraiser.
We had argued it initially, Judge, some of the business people there in Hall County did the Appalachian Strong T-shirts.
As in the company made the T-shirts, or there was a in the community fundraiser there?
Well, they made the shirts there and
Okay.
of course sold them there.
Okay.
And as I understand, it was about $50,000 that was raised from the making of these T-shirts. The primary concern that we have is that demographically it doesn't match. It's in the same.
Don't send it to
Well,
Fulton.
you got the same news programs there as you do here. So we really haven't changed anything much except this very small epicenter. And I would venture to say it probably doesn't take much longer to get from this courthouse to the Jackson County Courthouse than it would to get here to the Hall County Courthouse. I don't know, I haven't driven it, but it's pretty close. And I assume if the court does Hall County, that you'll allow people to drive back and forth in Hall County here every day.
So I will discuss some logistics with y'all a little later. I will make arrangements. Go ahead.
But that's what our concern is, Judge. It's just not far enough away. I think that we're still in that epicenter of where this occurred. And I think that you're going to have people in Hall County as a neighboring county. Even though it's TIP, it's still neighboring county. And of course, the other county in your jurisdiction covers a lot more of the territory. It's in the same jurisdiction.
Right.
So we're just very concerned about that. I know the court wants to try to accommodate everybody and do the right thing, but we feel like we need to be a little bit farther away. This is just too close. We're demographically not the same. And
is there a case that says the demographics are a problem? And specifically, when you say the demographics aren't the same, is there a specific allegation there?
well, the percentage of black-white is different.
How different?
See if I've got my notes on it. I don't think I brought my notes up on that.
Because I think the percentage of at least white is the same or a percentage less than at least one of the counties suggested by you guys in your original request for South Georgia.
I think from the standpoint of the number of people, they're about 2.5 times. Or
It is a bigger population.
correct.
No question. So obviously I reached out to, it's in the order. I reached out to the South County Georgias that were recommended by the defense. None of those were going to be able to accommodate us. Certainly not on our September trial schedule. Now, if we went into 2026, one of them seemed more likely to be able to try and make it work. So the trial dates present some problem. We're also talking about, I'm being told, a 3-week trial. So we're also talking about disrupting the lives of jurors, which is going to be a big ask for 3 weeks or so. And what we want is to not have a jury get, once they're seated, not get tainted, not lose jurors for any improper.
In my opinion, that should not be a consideration, because if you're moving it to boom, their lives will be disrupted if you have it in this county, Hall County, or somewhere in South Georgia. Lives will be interrupted.
Proper conduct or improper information that they've received outside of the trial. So I really was reluctant and am reluctant to put jurors in a hotel for 3 weeks. So that means I need, with that in mind, that means I need to be able to get the jurors here in a reasonable amount of time and back each day. If I put them in a hotel, I don't think that we've eliminated the problems that we have with sequestering a jury, unless I take their cell phones away. And I can't imagine in this day and age taking the cell phones from jurors for 3 weeks. So I think, and again, I may prove to be wrong, but I think allowing them to continue some normalcy of life increases the odds that we don't have jurors do something they're not supposed to do over the course of a 3-week trial, which did limit how far away I could go. Now, the other looming problem is finding some other place that can accommodate us for a 3-week jury trial. We had kind of already earmarked some time here and were able to arrange things, which is, I have more control here than I do anywhere else. Normally, and correct me if I'm wrong, but in a change of venue, you usually go through where the crime occurred, trying the case where the crime occurred. In other words, here in Barrow County, we're doing jury selection, and then we find out
Hey, you came in while they are discussing moving the venue.
Yeah,
Because-
I've never had to move a venue before. I understand that they're like the county next door, but it's the same demographics.
Yeah, and apparently because the judge said we can move it to Hall County or take the jury in from Hall County. And now the defense brought up that in Hall County, they made a fundraiser for T-shirts about convicting Colin Gray and raised $50,000.
I think the idea is to get people that are not impacted by this case on the jury, right?
Yeah,
I don't think that's a good count.
They want it down in South Georgia, and apparently there is no chance this year for a 3-week trial, but maybe in 2026, one of these counties can fit it in.
So this might delay the trial then, and it won't go in September.
Yeah.
All right.
I mean, for the defendant, yeah, move it. For me, I mean, September is a bad date anyway, because I will be in USA,
Yeah.
I will be in Utah, and then in Miami, and I will be covering the YNW Melly trial.
Yeah, move it to 2026 for Nick.
Yeah, for me, for absolute selfish reasons, move the trial to next year. Yeah. But I understand from the defendant's point of view, Jesus Christ, get me out of here.
Yeah.
Did the boy stay with his dad, or was he in between? It seems like the dad had the majority of the custody.
Yeah.
After that event with the mother locking the kids out in the cold for hours.
Imagine that. Your ex screws up your kid. You get custody of him, try to get him on the right path, then he screws up something because of what your ex did. And then now you're on the hook for it. Yeah. That's how I see this. I might be a little jaded.
Yeah, but you should go back and listen to the prosecution. They got even worse in their rebuttal argument.
Really? I'll have to go back.
Yeah.
I finally got through my hearings.
Yeah, because she argued against the analogy that he mentioned about car keys. Car keys, kids takes car keys, go on the road, kill somebody. Vehicular manslaughter, vehicular homicide is the dad. And apparently, according to the state, yes, if he knew the intent was to kill somebody, or if he had sufficient warning that he might run somebody over. And I mean, this is stupid.
The Wayne County prosecutor was being pressured to bring charges against a parent for the same thing, and she said no. She's like, no, I'm not doing this. For the car driving radical thing.
And then they argued about the state is only alleging on or about September 4th. But when was the warning? What was the warning? How can we defend ourselves against a warning that is not in the indictment? All it says is the warning, sufficient warning or whatever, on or about September 4th. And then, in my opinion, then you really have to be specific about what was the warning. And the chat brought it up that the state really don't want to talk about 2023 when FBI came knocking and found no probable cause for bringing a case. So
in Michigan, we're a notice state. You have to give just enough notice to know what the charges are, and that's it. They don't have to give you all the details, which
no.
Sometimes it's good. So has he had a preliminary examination? Do those exist?
I see here from 8 months ago, Colin Gray preliminary hearing for half an hour, and then I have one live hearing an hour and a half, but it only says Georgia versus Colin Gray, and it's for a detention hearing.
I don't know.
Yeah, so so there are 2 full hearings prior to this that I can find now, at least.
Okay.
And another thing that the prosecutor argued we believe it's sufficient because we don't have to give them everything.
Yeah.
Yeah, but that is an all or nothing argument. That's a fallacy. No, you don't have to give them everything, but you have to give them something so that they can defend them.
Yeah, I don't know what stage this is under their rules. Like in Michigan, we would have almost everything at this point.
Oh yeah, the final date of discovery was yesterday. And today, the state said, yeah, we still have some outstanding things. and I was like, yeah, whatever that discovery is.
Right.
Yeah, but of course, the judge said, yeah, I will give you another month.
Okay.
Yeah.
Well, let's see what he has to say about moving, I suppose.
Yeah. We are into the final 5 minutes now.
A higher percentage of the jurors can't be impartial. So we're removing that, at least in some degree, by bringing jurors in from somewhere else. I realize it's not as far as you would like. And certainly we may be in jury selection and find out that too many of the jurors there can't be impartial. And that puts us where we would have been if we'd have tried to get the jury here. Either way, whether I try and find somewhere else, which is going to be 2026, or we try it with Hall County jurors and find out that perhaps we can't get a fair jury there, we're still going to be 2026, going somewhere else, doing it again. I realize, and I knew the order wouldn't make everybody happy, and I realize that it may ultimately prove to be a bad decision. But I think it's worked, since we already have plans to try this in September. We have the ability to do it here. I think it's worth getting a jury from somewhere else that's close enough to get them here and back every day without them having to stay in a hotel for 3 weeks. And if I'm wrong and we find that out in those 3 days of jury selection or 2 days of jury selection, then either way, we're in 2026 trying this thing.
Yeah, but the difference is you're now in June and they have an opening maybe early 2026. If we wait till September, they might not have that opening anymore.
Sorry, I didn't catch any of that.
Yeah, he was arguing if we go through with the jury selection from Hall County and we find out.
I did hear that. Yeah. He's not going to stop it halfway through.
No. He will just bring in another batch until he has.
Mm-hmm.
But his argument here is, well, if we find out that we can't get enough jurors, then it's still 2026. Yeah, but the difference is now it's June. You know you have a date in 2026. Wait until September, they will have filled that spot. So I don't think he will do anything about it.
And if it happens that we can't get them in Hall County, then I'm much more likely to try and go to South Georgia or make plans in advance where somebody can accommodate us. So I certainly understand the motion, but I don't intend to grant it.
And, just to let the judge know, I know you want to get it tried in September
Yes,
of this year. But there may be some impediments to doing that anyway, depending on what we may want to take up. So if we do that, it may put it into 26 anyway. So if that's the case, then I've been doing this for a minute. I know
Yes,
what
sir.
it's like to spend 2.5 weeks of voir dire and not be able to get a jury. So I certainly would like to avoid that, and I know everybody would like to avoid that. I know you want to accommodate the DA's office and the witnesses. We drive an hour and 45 minutes every day to get here.
Yes, sir.
So that's not outside the realm either. Maybe we could go up towards Chattanooga. They don't have the same news media coverage to get it out of Chattanooga instead of Atlanta. So I just want to keep that open for the court if you see that we may have to go in 26.
Yes, sir. And I'll keep that one to myself. If there's anything that y'all see on the horizon, either side, that is going to be an impediment to trying this as we have it scheduled, let me know as soon as possible, because if we do need to make changes, I want to know about those as early as possible. We've put a lot on hold here for the 3-week trial, that if we're not doing it then we can adjust the court schedule here so that other cases can be tried.
3 weeks is a long trial.
Yeah.
I do have just some logistics to discuss if council are
Or you can dismiss the
comfortable
case
coming to
because
chambers after you pack
the
up
case will
here.
be charged.
Yes, Your Honor.
All right, thank you.
Thank you, Judge.
Yes, sir.
Oh, that's it.
That's it. That's it.
All right. Well, looks like the judge is going to deny the motions. I wonder if they filed an interlocutory appeal like Crumbley's did. They filed. They went to the Court of Appeals to get the case dismissed, and I'm wondering if they did that here. It doesn't sound like it.
No, at least not yet. But I don't know what happened in the other hearings. But we are 2 hours in, and the other hearing is an hour and a half. And with my commentary and my breaks, that will be a 3-hour stream.
Yeah.
And I don't have the time to sit here for another 3 hours. But I do know, tomorrow I can do another one of these hearings and start from the first. And get some more time to read up on this. And then Thursday you have no court because it's a Juneteenth federal holiday.
Yeah, that's right.
And by then, I suppose we have the verdict in the Karen Reed case. Oh, did you see the jury questions?
No. What were the jury questions?
Jury questions were: 1, what is the time frame for the OUI charge? OUI at 12:45 or 5 a.m.?
Oh, interesting. So they are thinking about the OWI charge.
Yeah. 2, are video clips of Karen's interviews evidence? How can we consider them?
Really?
And number 3 is, does convicted guilty on a sub-charge convict on overall charge? That is
They're definitely looking at just doing a straight up OWI. That's my thought.
That was my interpretation as well. That
Nice. When did those come out?
About half an hour ago.
Oh, okay. Nice.
So that will be interesting.
I'm going to go harass Baker in his chat real quick.
Yeah. Yeah. But, I mean, this will be an interesting case that I will actually try to follow.
Yeah.
I'm not so interested in the kids because, he was caught there with a gun. Yeah.
Mm-hmm.
From my point of view, it's really not an interesting case, a school shooting, even though I can understand why many want to see him get convicted. But for me, that's not interesting because it's a quadruple homicide. And by all accounts, I know innocent unless proven guilty. But when you're caught in school with a gun after you shoot a lot of kids and teachers, yeah.
Does this guy have to sit in jail until they figure this out? When? Yeah. Well, I don't know if he has bond or not, but he's definitely in jail right now.
Yeah.
So.
And the severity of the charges, you can be held without bail, but I don't think
you could
this
be.
Is
I think. I mean, I don't know Georgia law. I don't know. But
in Fulton County, they have people in jail for. I saw this from. What's his name? I saw it. I wonder if it was Happily Angry Lawyer who found a guy who has been in jail in Fulton County without a trial for 15 years.
Oh my God. How is that? How is there not a writ
Mm.
of habeas writ? How was that never filed? To get him out of
I
there?
don't know. Other than what he's said on it in a tweet, I don't know anything about that case. I
He's
know there
probably
are
convicted of something, sentenced to 25 years, but there's still that one trial that hasn't happened yet. So
maybe
he's
I don't
keeping
know.
him in jail instead of moving him to the state
Yeah.
pen.
But for instance, now with the new trial in Fulton County, the cash out.
Oh yeah.
That
yeah.
he has been in jail since 2022 as well.
Huh.
But since the YSL RICO was ongoing, his RICO couldn't start.
Nice.
So he's been in jail since.
Just plead
March.
his time served and get out of there, man. That's what I
Yeah.
say. The
I mean,
state's got you over a barrel.
Yeah, I mean, at what point is jail just a way to get plea deals, regardless if a
Oh, it
person
has
did it
been
or
for
not?
the last 50 years.
Yeah.
It's exactly
If you
what it
can't
is.
if you can't afford bail, plead out.
Yeah.
It's that easy.
Move on with your life, man. It's like, well, I'll have a criminal conviction for something I didn't do. There's so many
Yeah.
times when I have clients that they're being sentenced on something as habitual offenders. And I'm like, but that underlying crime I didn't do. I just pled to it. It's like, but that plea meant something to the system, right? And so now you are a prior felon.
Mhm.
So it's bad. There's a great podcast that goes in depth in the Cincinnati court system. Cincinnati, Ohio. Wait, no, Cleveland, Ohio. And they do an in-depth study. The podcast came out, or season 2, which is this Cleveland stuff, came out. What the hell is it called? I don't know. I figured it out. I'll post about it, but it's really good. They do an in-depth study on Cleveland and how they basically stack charges and then offer these plea deals. And guys sit in jail until they take the lowest of the charge. They got their time served and move on. But now they have criminal records.
Yeah, but that is for another stream. I will come back tomorrow with more hearings because I want to know more about this case, and the easiest is to watch the hearings and read up on it.
Yeah.
So
sounds good.
yeah, so thanks Dave for showing up, and thank you guys out there on Rumble, on X, and here on YouTube. Thank you. And I will send you off to watch to Dave's big dismay, Baby Goats. All right. See you all.
See ya.
Bye.